Good morning. It's time for another interactive feature, Mailbag. So, please give me any inquiries by email, and we'll address them here on the next lecture. Thank you. Welcome to the second installment of the Emergency Lecture Series, presented again online. This time, Chapter 15 is the final chapter of the common law contract portion of this class. The next chapter will involve the Uniform Commercial Code, sales and lease provisions, which, while they are a species of contract law, are a statutorily enacted species of contract law. So, make sure that you get this material down because the bulk of it is applicable to the Uniform Commercial Code as well. The Uniform Commercial Code probably being the most important portion of this class for the general business major. I think this is a good time to note that Cengage, for the duration of the educational emergency that we're having in the spring semester of 2020, is offering all of its materials online for free to literally everybody. So if you do not have or have not had access to the online version of the 12th edition of Business Law Today by Miller, you can go to Cengage and get that, as well as online access to every single one of their publications. I highly recommend that you do so, simply because, as you know, you should have been reading each one of these chapters in the book, as well as attending the lectures and going through whatever other interactive exercises we come up with. I will be also posting and sending you emails regarding some other activities that we're going to put together this week. As you know, a breach of contract is a failure by one of the parties to perform the promises that were made to the other party. In this chapter, we're going to review just what the remedies are for a breach. First, we'll go over damages. These are usually known as legal damages or remedies at law. Second, we'll go over equitable remedies. These are remedies that were created by the chancellery courts or any court now sitting in chancery, since we have a combination of the law courts and the chancery courts under the modern system. Third, we have recoveries that are based on quasi-contract. As you will recall, a quasi-contract is not an actual contract, but it involves the various scenarios where we attempt to make parties whole based on the fact that we want to prevent unjust enrichment. And then finally, we have contract provisions. These are provisions that are contained inside the contracts themselves that limit remedies in some fashion, whether limiting the amount of damages or determining an amount of damages that's going to be assumed in the event that there is a breach or any other type of remedy. Learning objectives for this chapter include the following: what the standard measure of compensatory damages is when a contract is breached, when the courts grant specific performance, which is an equitable remedy, as a remedy for a breach, what remedy is available when a court imposes a quasi-contract, which you might recall we have talked about at least somewhat in the past in connection with unjust enrichment. And finally, what is a limitation of liability clause, and when will the courts enforce such a clause? Types of monetary damages. A breach of contract entitles a non-breaching party to sue for monetary damages, including compensatory damages. These are damages that compensate the non-breaching party for the injuries or losses actually sustained as a result of the breach. Consequential damages. These are foreseeable damages that result from a party's breach of contract but are caused by special circumstances beyond the contract itself. Punitive damages. These damages are designed to punish a wrongdoer and to deter similar conduct in the future. Accordingly, such damages are generally not recoverable in breach of contract actions unless the breaching party's actions give rise to a separate tort claim. Nominal damages, which we've also seen before, particularly in the case of slander and libel, it's a small monetary award granted to the non-breaching party when no actual damage was suffered. Now in more detail, compensatory damages. Damages that compensate the non-breaching party for the injuries or losses actually sustained as a result of the breach. Thus, the standard measure of compensatory damages is the difference between the value of the breaching party's promised performance under the contract and the value of his or her actual performance. This amount is reduced by any loss that the injured party has avoided. Expenses that are directly incurred because of a breach of contract, such as those incurred to obtain performance from another source, are called incidental damages. In cases involving contracts for the sale of goods or, in most states, land, compensatory damages generally equal the difference between the contract price of the goods or land and the fair market price at the time the goods or title to the land was to be delivered. In cases involving construction contracts, the measure of damages depends on which party breaches and when the breach occurs. Exhibit 15-1 shows the measure of damages for various types of breach of construction contracts. For instance, if the owner is the party in breach, and the time of breach is before construction has begun, then the measure of damages is profits. That is, the contract price less the cost of materials and labor. If the party in breach is the owner, and the time of breach is during construction, then the measure of damages will be profits plus costs incurred up to the time of the breach. In the event the party who is breaching is the owner and the breach occurs after construction is completed, the measure of damages is the full contract price plus interest. If the party in breach is the contractor, construction has not yet begun, the measure of damages is the cost in excess of the contract price to complete the work. If the contractor is the party in breach and the time of breach is after construction has begun but before construction is completed, the measure of damages is generally going to be all costs incurred by the owner to complete construction. Now to reiterate, consequential damages are foreseeable damages that result from a party's breach of contract but are caused by special circumstances beyond the contract itself. Punitive damages are those damages designed to punish a wrongdoer and to deter similar conduct in the future. Again, such damages are generally not recoverable in a breach of contract action unless the breaching parties' actions have given rise to a separate tort claim. Finally, nominal damages are a small monetary award, often $1, granted to a plaintiff when no actual damage was suffered. Mitigation. Mitigation of damages is, in contract cases, a requirement that the plaintiff do whatever is reasonable to minimize the damages that are caused to the plaintiff by the defendant's breach of contract. For example, in most instances, people who are fired by their employer, regardless of the reason, must try to find a new job. Likewise, if a tenant abandons a rental property, the landlord has a duty to find a new tenant and lease the property. Obviously, under those circumstances, the landlord is not entitled to both recover rent from the new party and damages from the one who breached. The case of Hadley versus Baxendale is found on page 377 of Miller. The rule that requires a breaching party to have notice of special, quote, consequential, close quote, circumstances that will result in additional loss to the non-breaching party before consequential damages can be awarded was first enunciated in Hadley v. Baxendale, a landmark case decided in England in 1854. The case involved a broken crankshaft used in a flour mill run by the Hadley family in Gloucester, England. The crankshaft attached to the steam engine in the mill broke, and the shaft had to be sent to a foundry in Greenwich so that a new shaft could be made to fit the engine. The Hadleys hired Baxendale, a common carrier, to transport the shaft from Gloucester to Greenwich. Baxendale received payment in advance and promised to deliver the shaft the following day. It was not delivered for several days, however. The Hadleys had no extra crankshaft on hand to use, so they had to close the mill during these days. The Hadleys sued Baxendale to recover the profits they lost during that time. Baxendale contended that the loss of profits was too remote. In the mid-1800s, it was common knowledge that large mills such as that run by the Hadleys normally had more than one crankshaft in case the main one broke and had to be repaired. It is against this background that the parties presented their arguments on whether the damages resulting from the loss of profits while the crankshaft was out for repair were too remote to be recoverable. What do you think? The Hadleys lost. The rule enunciated by the court still applies. When damages are awarded, compensation is given only for those injuries that the defendant could reasonably have foreseen as a probable result of the usual course of events following a breach. If the alleged injury is outside the usual and foreseeable course of events, the plaintiff must show specifically that the defendant had reason to know the facts and foresee the injury. Liquidated damages and penalties. Liquidated damages. Contracts often contain provisions requiring the breaching party to pay a certain dollar amount if he fails to perform as required. These provisions are enforceable as long as, when the parties formed the contract, damages from a party's breach were difficult to estimate, and the amount of liquidated damages was a reasonable estimate of the value of the promised performance. A penalty, on the other hand, is a sum specified in a contract not as a measure of compensation for its breach, but rather as a punishment for a default. The agreement as to the amount will not be enforced, and recovery will be limited to the actual damages. So, in order to determine whether or not a provision is actually a penalty and thus not enforceable and limited to actual damages, or is an appropriate liquidated damages provision and is enforceable at the amount that is established in the contract, first look at whether or not it is apparent at the time that the contract was formed that damages would be difficult to estimate in the event of a breach. If so, then consider whether or not the amount that is set as damages is a reasonable estimate and is not excessive. You'll recall that one of the common uses of a liquidated damage provision was in the case of covenants not to compete, which of course already start with at least one strike against them as being, generally speaking, against public policy because they're considered to be in restraint of trade. So, accordingly, if you're talking about somebody selling a business for a couple $100,000 and then establishing a liquidated damages provision if, in fact, that person does compete, contrary to their covenant not to compete, of $1 million, even if it's apparent that it would be difficult to estimate the amount of damages in the event of a breach, the amount of $1 million is not a reasonable estimate and is excessive when compared to the purchase price of a couple $100,000 for a business. You will also find common uses of liquidated damages provisions in a number of other areas where parties have agreed to forego actions as versus undertaking particular duties. Another common use of a liquidated damage provision is in construction contracts. For instance, provisions will provide that for each day of delay beyond the anticipated completion of a construction contract, that the contractor will pay a set amount of funds, as an example. A synopsis of the case, Kent State University versus Ford, which was decided in Ohio in 2015, is found on page 379 of Miller. Gene Ford signed a 5-year contract with Kent State to work as the head coach for the men's basketball team for the paltry sum of $300,000 per year. Contract provided that if Ford quit before the end of the 5 years, he would pay the school liquidated damages equal to his salary times the number of years remaining on the contract. Ford was told by the athletic director that the contract would probably be renegotiated before the end of the term. But Ford only stayed 1 year and left for Bradley University at an annual salary of $700,000 per year. Kent State was thoroughly miffed and filed a suit against Ford alleging breach of contract, and the court enforced the liquidated damages clause and awarded the university $1.2 million. Ford appealed, arguing that it was in fact an unenforceable penalty clause. The issue was whether or not the liquidated damages clause was enforceable, and the intermediate appellate court agreed with the lower court that in fact it was. The clause wasn't a penalty. There was justification for seeking liquidated damages because at the time that the contract was negotiated, the damages that would result from a breach were difficult, if not impossible, to determine. Resignation of a head coach from the university's basketball team may cause a loss in ticket sales and a drop in community and alumni support for the team, much as an outbreak of the coronavirus might. The university's ability to recruit players may also be affected. Of course, the search for a new coach and a coaching staff will be required. Those efforts are not easy to measure before they happen, especially considering that such results may be different at different times in a coach's tenure. The statement that the contract would be renegotiated indicated that Kent State was interested in the stability of those factors. And in this case, based on the record, the damages were reasonable. The salary that Bradley was willing to pay showed that Ford was a person of skill and experience who would have been valuable to Kent State. There was also an asserted decrease in ticket sales, costs associated with the trip for the coaching search, additional potential sums that might be expended. So that's an example of the enforceability of a liquid damages clause. Equitable remedies. In addition to the various types of money damages, there are several equitable remedies available. Rescission is one of those, canceling a contract and returning the parties to their pre-contract position. Restitution is another, returning goods, properties, or money, or in the case of goods or property, their value in money, previously transferred in order to restore the non-breaching party to his pre-contract position. Restitution is not just limited to rescission cases, but in every rescission case, there is mutual restitution. Specific performance. Requiring the breaching party to perform exactly as called for in the contract. Courts usually order specific performance only when money damages are an inadequate remedy and the subject matter of the contract is unique. For instance, a contract to purchase an original Picasso or a particular tract of land. Courts almost never order specific performance of a personal services contract, such as a contract to play as a wide receiver for the Jacksonville Jaguars, for instance. Reformation. Reformation is an equitable remedy used when the parties have imperfectly expressed their agreement in writing and allows the contract to be rewritten by the court to reflect the party's true intent. This remedy is typically available only in cases of fraud, mutual mistake, incorrect written statement of the party's oral agreement, and covenants not to compete. Since, in general, courts don't like to go outside of the contract's intention as manifested either in an oral agreement or in the writing that constitutes the contract. Once again, Professor Miller has provided us with a handy chart demonstrating, in this case, the remedies for a breach of contract. The remedies available to the non-breaching party include damages, under which we have the categories compensatory, consequential, rarely punitive damages, nominal damages, and liquidated damages. We also have the possibility of rescission and restitution, or alternatively, the other equitable remedies of either specific performance or reformation. Okay, folks, recall that a quasi-contract is not, in fact, a contract at all, but is something that is being treated as similar to a contract in order to prevent um, some unjust enrichment. So, quasi-contractual recovery is particularly useful when a dispute arises, but there is no actual contract, or when one party has partially performed under a contract that subsequently becomes unenforceable, whether it's because of a change of law or something else that renders that contract void. The party seeking to recover must show the following. First, that he conferred a benefit on the other party. Second, that he was reasonably expecting to be paid or otherwise compensated for the benefit which was conferred, although not necessarily by the party on whom it was being conferred. That he did not voluntarily confer benefits for which he did not intend to be paid, and allowing the party receiving the benefit to retain the benefit without paying for it would unjustly enrich that party receiving the benefit. Contract provisions, limiting remedies, and a kind of foreshadowing of the next several chapters involving the Uniform Commercial Code. We observe that remedies can be limited in the contract for the sale of goods. But every contract may include provisions stating that damages are unrecoverable for certain types of breaches, or that damages may be limited to a maximum amount, or that any breach will result in replacement, repair, or refund of the purchase price. Provisions that state that no damages can be recovered are called exculpatory clauses. We have come across those briefly in the past. Provisions that affect the availability of certain remedies, which is what we're talking about now, are called limitation of liability clauses. Okay, that concludes material on common law contracts. We still have a couple of chapters on contractual relationships established under the Uniform Commercial Code, followed by negotiable instruments, which I think is a very important aspect of business law. We're going to skip international and space law and banking in the digital age. If you are going to wind up with a career in banking, they're going to teach you what they want you to know. Security interests and creditors' rights, however, because that is of commercial interest generally, we will cover as likewise the related topic of bankruptcy. And then we'll see what else we can squeeze in for the rest of this book before the end of the term. Thanks. Bye-bye.